And we are live from the East Coast to Hawaii. Welcome everyone to Affirmativ's webcast, your Social Security intake process reimagined, featuring our guest presenter, attorney and consultant, the renowned Jim Brown. I'm Nathan Chapman, President at Affirmative. Before we get started, let's do a little housekeeping. This webinar will be recorded, so you'll receive a follow-up email with a link to that recording. You'll also receive a webinar survey. We ask you to take a moment to complete the survey so we can continue to bring you the quality legal marketing educational programs that you want to hear. On this next slide, I'm showing you an example of the attendee interface. You could submit text questions and comments throughout the presentation by typing your questions in the questions pane of the control panel. You can send your questions at any time during the presentation. As moderator, I'll decide whether to jump in and interrupt Jim or to hold it to the end when we will have a question and answer time. I'll tell you, yesterday during our rehearsal, we were playing, let's see if we can stump Jim Brown. We were tossing all kinds of questions at him, and they were all little priceless pieces of wonderful information. So I know you're going to want to stay tuned for that. That's my favorite part, in fact. All right, before I turn it over to Jim, I wanted to take just a couple of minutes to tell you some of the perspective that we see here at Affirmative. Your intake process is just as important as how you handle your hearings. In fact, we work with a lot of disability firms all over the country, and the ones that we see most successful are the ones where top management pays attention to that intake process and actively manages it. Your intake team should be full-time. If you're just going to have a paralegal trying to squeeze in calls in between doing all his or her other work, you're just not going to be as successful. If it's absolutely impossible for your intake people to be full-time, then you might want to consider a call center. Actually, there's other reasons to consider a call center also. There you have a team of people doing nothing but staring at the screens, and they're 24/7, and they can speak Spanish also. But one way or another, you really need to have your resources focused on the intake process. Your attorneys should be involved regularly and checking out every day what's going on. That's the lifeblood, is the intake process. These days at Affirmative, we have more tools that we can offer you in terms of being able to manage that process. Here's an example of the dashboard. I'm not going to take you through how to read it exactly, but it will tell you what, calls or leads, web form leads have come in and when and how long, they were engaged. It even can offer recordings of the calls. I know there are laws about recording. We can help you navigate through all of that and, have the recording, this call will be recorded for quality assurance, if you like. Because that, in fact, is exactly what we're talking about, is recording the calls for ongoing training and that quality assurance. You should regularly monitor this dashboard. When you come in the morning, the first thing you should do is see what came in overnight and what happened to them. And throughout the day, you should be looking to see, what was possibly missed. Can you call them back and get them going? What kind of information is here that you can use for ongoing training? With all of that said, I'm looking forward to hearing the wisdom from our guest presenter, Jim Brown. I've personally been working in legal marketing for over 25 years, and I think I've known Jim pretty much from the start. I once heard Jim say that he can make a nice living on all the leads and missed opportunities that most law firms let fall through the cracks of their intake process, and I believe him. I've seen it happen. I've seen him turn around situations at a number of law firms. Affirmative has invested heavily over the years to develop what we think is the nation's most effective legal marketing, but the part we don't have any control is what happens once that lead goes to your intake team. An identical marketing program can soar or crash on the rocks depending on the team, so that's why today's program is so important. Jim founded Attorney Consultant, Inc. in 2003. He's now known as the nation's leading consultant for small and medium-sized law firms. Jim helps law firms improve their intake processes, case management, hearing and trial preparation, and he's often brought in when attorneys are buying or selling practices. He's also an expert in representing lawyers who get a letter from Social Security's Office of General Counsel alleging ethics violations. That's something you want to take seriously and call Jim Brown. Jim has testified before congressional committees numerous times and was featured on a CBS special with Bill Moyer about people falling through the Reagan Social Security disability safety nets. So he knows what he's talking about, and I'm looking forward to hearing what he has to say today. Thank you, Jim. Take it away.
Thank you, Nathan. Being a man or a woman is a matter of birth. Being a man or a woman who makes a difference in the lives of others is a matter of choice. I hope that's why you're representing people on disability claims. In the 90s, when I was bringing in over 200 clients per month, every new client still excited me. I always worried that tomorrow I might not bring in a new client. I was always vigilant about making sure my staff followed the procedures I created for new clients. And I always spot checks to make sure that they were doing the procedures the way I created them. Equally important, however, was that I was always willing to listen to ideas from staff, other attorneys, marketing people, or anyone else who might open my eyes to ways to improve what I was doing. The Government Accounting Office estimates that 30% of the people eligible for Social Security disability never sign up. Most of those don't even know it exists. Many of those are told that they're not eligible or they don't have a good enough claim. That's our fault. We're turning away people who are eligible. And we have to open our eyes, wake up, and not turn away the people who need our help. We should wake up. We should take care of the people who are calling us that we can help. Sign them up and win their claims. One of the most important things I learned early in life, long before I became an attorney, was never to say why, but to say why not. Think of that when you hear ideas today and the future about your practice. Today we're going to do a brief introduction. We're going to talk about what's important on intakes, how to keep your intakes organized. Do you understand who you should represent and how you can make sure you're not missing the cases that you should be taking? And how to be fast, thorough, and organized when you or your staff are doing it. What confronts you? It's a good life lesson. It's what you face every day in the intake system you've established, and how do you deal with it? You're confronting that ferocious tiger in the room. And when you see it, do you run? Are you running away from it? Or do you stop, face it, and use the brain you have to decide how to confront that tiger in the room? Social Security is confronting you. That's what we're talking about today. What's been running you? Bad judges, non-cooperative doctors, difficult time limits. Your staff often is the biggest problem any of us have. DDS. But your intakes, done properly, can keep your practice from imploding and make you more successful. But the things that make your practice successful are often the things that keep your practice from becoming even more successful. We're so busy every day just getting along, doing what's happening, that we have blinders on. We're not looking to the right or left to see what we can do to make us even better. And that's what we have to do. Open your eyes, look around, and see what you can do to be an even better lawyer, to have an even better business, because those two go hand in hand. COVID-19 is a nightmare for our country and for the world, but it can also be a blessing for your practice. There's going to be a lot of claims, and you're going to have a lot of initial applications calling you soon. Are you going to try to get them? Are you going to welcome them into your office? Are you going to work them properly? If you're not working those claims, you're not doing the job that the people are calling you about. Are you winning at least 50% of them? If you can't win 50% of your applications, you're not doing them properly. COVID-19 is going to generate new cases, and there's going to be a lot of mental health cases. It's happening already. I'm seeing it. A lot of the firms I consult for are seeing it. There's people with anxiety, with depression. How are you going to handle it? One thing I've recommended for a long time, but it's even more crucial now, is empathy training. Find someone who can do empathy training for your staff. A few extra words to the new client, to your existing clients, and even for your staff who's working at home, who's having stressors of their own, will do wonders. Empathy training gives them some key things to say to prospective clients and current clients to help get them through these difficult times, to make them know that you're the law firm they need to represent them. Take a look at this. $5,700, $4,263, $2,894. Those were 3 initial app fees I got earlier this week. That's right, just this week. I didn't compete with other clients who were denied and looking for representation. I didn't wait over 2 years for a fee on those cases. Those cases each took less than 30 minutes of my time. They all took less than 4 hours of staff time. Divide the time spent on those cases by the fees I earned. How could you pass that up? That's just money in the bank that you should be earning on every initial application. Take the initials. You can make a fair fee. More importantly, you can do a good service for your clients. Some people say, why should I take initials? I'm not doing anything. If you feel that way, you're not. But when I get an initial application, we do the application and we immediately send for medical records, send a medical source statement to the doctors, and when we get that all back, we file a memo to the state agency. People at DDS are evaluated on quantity, not quality. When I get the medical records, when I send them a memo telling them what the 5 to 7 or 10,000 pages of records say, they don't look at them. They know I will only tell them the truth. And my cases are paid because I'm giving them the information they need. Initials help your practice, they help you, your bottom line, and they help your clients. Word spreads through your community that you win cases faster. I'm not going to talk just about initials today, though. We're going to talk about intakes in general. What's important on intakes? Good intakes win more cases. Think about that. If your intake staff does a good job, you're going to win more cases. They can't rush. They have to make that prospective client comfortable. That prospective client has to know that you're a firm that does a good job and that cares about them. They have to give them their complete attention. Don't be interrupted by anything. Don't let anybody come in and ask a question. When you're talking to a prospective client or to any client, they deserve your attention. Be a friend. Don't just fill out a form when you're doing an intake. Ask about that client. Ask about their life. Empathize with them. Be a partner. Every client I get knows that they're my partner on their case. We have to work together or they're not going to win. Put yourself in your prospective client's place. Empathize, be courteous, be compassionate. Those 3 things go a long way toward making that person comfortable. Right now, you're emailing or mailing the forms to them. How many are coming back? The more that person's comfortable with your firm, with who's talking to them, the faster those forms come back. Build rapport with prospects. Sense their mood and respond appropriately. Say, tell me about. When you say, tell me about the doctor you see. Tell me about the job you had to leave. Tell me about what it was like when you were going to church and now you can't go because you can't sit anymore. Tell me about things. It's a nice segue into letting them tell you something. Emphasize how unfair the system is. Tell them it's a shame they have to hire you. Nobody who needs to file for disability wants to. They'd much rather be working. They'd much rather be enjoying their life. This is terrible for them. Emphasize with them. Be kind. Be courteous. Let them know that you understand what they're going through. Ask what they're looking for. They want their day in court. They want to tell their story. They want someone to hear them and believe them. But let them know you're going to try and win faster. If you can win without giving them their day in court, they're going to get a quicker decision. They're their money sooner. You don't want them to wait. You want to help them. That's your job. Let them know how serious their case is. Don't let them know that you can win easily. They have to know that their case is difficult, but you're the firm that can help them. It can be a 58-year-old uneducated factory worker who's only done heavy work with 3 back surgeries and a heart condition. They still have to know that case is difficult, but you have the understanding and the experience to help them. If they know you're the person that can do the job for them, they're more likely to hire you. If they think their case is easy, why do they need you? Or they'll look around, see who they might like better. Make every case sound difficult, but that they need your skill, your competence, and your understanding. They need you to represent them starting immediately. The longer they wait, the more difficult it will be. Keep your intakes organized. If you're scattered, you're not going to do a good job. You should have a form for intake. If it can be in your computer, in your case management software, that's the best place for it. I like to answer questions before they're asked. When I'm doing an initial application, I like to tell the client, this is going to take 6 to 8 months before we get a decision. And if your doctors give me all of the information I need as quickly as possible, we have a good chance. If your doctors don't corroborate everything, it's going to be more difficult. Tell them that before they ask. They like to know that you know what they're thinking. Show concern and show your experience. That's important. Both are important. You care about them, and your experience is what's going to help them. Make prospects more eager to retain you. I've had cases like yours in the past. I've had clients who have had this condition, and here's what I've done to help them. Make them know you understand what they're going through and how you're going to help them. Be organized. Every one of us has had clients who ramble. Here's what I do for the ramblers. I tell them, we may have a hearing someday, and judges have short attention spans. You have to answer my questions in as few words as possible. When I get all done with all my questions, I'm going to give you a chance to tell me everything you want to tell me. But first, answer the questions in as few words as possible. When you get all done, you will have covered just about everything they want to tell you, but you've gotten it done. You're going to have to remind them of the judge's short attention span several times during that interview because they will tend to start rambling a few times. But it's a way to keep them focused. Same thing when somebody in the background, because most of the interviews are on phone or Skype or FaceTime, wants to start piping in. The next thing, people who are disabled think no one listens to them. When they start to tell you something they've already told you, you can say, you've already told me that Dr. Smith is referring you to Dr. Jones for a consultation. Do you have anything you want to tell me that you haven't told me? When you do that, they know you've listened. If they know you've heard them, they tend to stop repeating themselves. You have to be logical and emotional. Give them a logical and an emotional reason to hire you. If they get home and tell their family, well, I hired this representative because they were so nice, the family's going to say, but do they know what they're doing? What are they going to do for you? On the other hand, if they go home and they tell their family, well, they sounded like they know what they're doing and he was a little curt and I didn't like him that much, that's not going to help either. You have to give them both. Whoever's talking to those prospective clients has to be friendly, courteous, concerned, almost loving about them. I'm going to care about you, but we're also good. We can help you more than anybody else. When you do that, they've got two good, solid reasons to hire your firm and not look anywhere else. When I consult for firms, I often call 8 to 12 of a firm's clients to talk about everything from the first time they called through whether they'll refer other people to them to how were the results. People don't understand the fee while the case is going on. Be clear about it. I can't tell you how many people I call who think they have to pay 25% of past due plus 25% of every check the rest of their life. Or they think they have to pay $6,000 whether they win or lose, or $6,000 plus 25%. Make it clear. I don't like to say 25% of your past due benefits. I like to say, when I win your case, you're going to get over $200,000 between now and the time you reach retirement age, and the most my fee will be is $6,000. Dollarize what you do. Let them know the value of what you're doing for them and how inexpensive your fee is. They're not sitting home upset because you're getting a fourth of their money. Now they think you're a bargain and they appreciate everything you do. Don't forget to say thank you. People in America don't say thank you anymore, and that's important. When they say, yes, I want you to represent me, say thank you. That's really important. But don't just say thank you. Tell them what you're going to do. I'm glad you decided to retain us. I'm sending you these forms to sign. We can't do anything until you get them back to us, but as soon as we do, we're going to file your initial application. We're going to file an appeal. We're going to send for medical. It's easy now that electronic signatures are accepted. You can talk to a new client, email them the forms, get those forms back, and file the initial application on that same phone call, or file an appeal on that same phone call. It's really simple, but tell them after you've done that what your next step is going to be. Let them know that you didn't just sign them up and put their file away. You're going to work for them now. And then send a letter thanking them for representing you. Tell them what you're going to do. If you email me, I'll send you a copy of the letter I use in that situation. It tells them when to call you, what they should call you about, and ask them to refer you their family and friends if they need help. I like to enclose a tchotchke with it. Tchotchke's a little gift, whether it's a magnet, a pen, just something that they can keep. The life of a refrigerator magnet is 7 years. Nice thing to give. It's nice to have a pen with your name on it to send if you're mailing forms to them. You'd be surprised how many clients don't have a pen at home to sign the forms with. Record those intakes, but be aware of the rules of your state. Some states require you to advise all employees. I had one client who listened to the recordings. One of his employees was just atrocious, and he was going to fire her until he found out that he had to advise all employees that they were being recorded, and he hadn't. He then told everybody she was just as bad, and he terminated her. Another client heard how bad his receptionist spoke to everyone. He told her she couldn't talk to clients that way. She said, if I can't talk to people that way, I don't want to work here. That was the last sentence she said as an employee. So find out what your state rules are if you're recording those. Recording them isn't enough. You have to listen to them. It's especially important if you have several people doing intakes. Listen to the recordings of the people who don't seem to be getting as good a response. Or you'll find some people are getting 80% of the packets back and some getting 40%. Listen to both and find out why. Listen to the rejections. Start with listening to people who they're not taking as clients over age 50. Sometimes you have to call a few of them, find out why they're rejecting them. In almost every instance, you'll find that your staff has turned away some clients that you wanted to accept. Find out why. Use those as a teaching method, though. Don't assume because you've told your staff what you'll accept as a client that they're going to always do it. Sometimes they don't. Constantly teach. Employees sometimes set their own criteria. Make sure they follow yours, but teach from their mistakes. When you're done, when the person's done doing the intake interview, I recommend doing a head to toe. By this, I mean, start with the top of their head. Say, do you get headaches? You'd be amazed at how many people have migraines but don't think that's disabling. May or may not be, but combined with everything else, it might be. Ask if they have problems with their neck, their shoulders. How many times do you go to the bathroom at night? Somebody who's getting up and going to the bathroom 8 to 10 times a night isn't getting a good night's sleep. That affects their ability to work during the day. If I get that, I tell them to usually keep a log of what time they got up and went to the bathroom. Keep it for 2 weeks. It's amazingly effective. Ask about their hips, ankles, and feet. But you'd be amazed at how many things your prospective client didn't think were important that combined with what they do think is important turns a so-so case into a good case. I like to score the prospects. This is for your intake department and let you know what you're doing. You set the amount of points that you say above this level we take the client, below the level we reject, and in the middle somebody more experienced makes the decision. If they have a severe cardiac problem, it can be between 2 and 5 points. Same with orthopedics, pulmonary. You set your own criteria on this. If they're a Title II, they have for sure they've worked 5 of the past 10, that's 5 points. If it's SSI, but you know that their income is below the level they need to get it, 2 points. Based on their earnings, 1 to 5 points. The person who was earning $100,000 a year and is applying for disability is a much more believable candidate than the person whose best earnings were $6,000 a year. Education, you rate points too. Vocational schools points, past relevant work you rate, and give your intake person 1 to 3 points for their own instinct. And then you get the total score. Once you've done that, you have a monthly management report to the partner's firm owner. How many calls received, how many calls made, and they get a report of how many cases were signed up at each point level. It's just a good way to see what the firm did. Now, just for an example, would you take this prospect? 51 years old, good work history, off work 16 months, 2 suicide attempts in the past 3 years, but no medical in the past 8 months. And he needs an initial app. Almost everybody I talk to says, no, we tell this person to get medical care and come back. And invariably, they get the medical care and go somewhere else. My recommendation is sign the person up, file the app, tell them where to get the medical care. Couple things happen. One is they're going to go get the medical care. Social Security may send them for a consultative exam. That's good. You win the case, you get a fee. Or they don't go see a psychologist. They get a terrible CE. They get denied. That happens. Don't appeal. Send them a letter that they need to get care. When they do, they should come back to you and you'll file a new claim. Don't waste your time in a case that you can't win because there's no medical to support any accrued benefits. It's worth a shot. For the time it takes to file a claim, when you don't have any real good medical going on and you've got a work history, do it. You're going to win a third of those cases if your gut reaction says this person sounds good. You have to let your clients know that they have to help you. You can't win the case without their help. But you also have to help Social Security. When you're doing claims, you have to get along with the people at the field office and at the DDS. If you get along with them, they're going to get along with you. When it's an appeal, sign them up, file the appeal, and if it's a recon, ask the field office to send you a disc with the file. They're going to be annoyed. They're not going to be happy. Your job isn't to keep them happy. Your job is to represent your client. I do it. When they don't send it to me, I ask for the office manager, the regional manager, and I have filed complaints with the U.S. representative that office is in. U.S. representatives love having congressional investigations done of field offices. When they do that, the people in the field office don't know how you were able to have that done, but they treat you like gold from then on. Anything you want, you get, because they don't know how you're so powerful, but they do it for you. If you're requesting a hearing and it's a new client, check ERE as soon as you can. See what's in that file and see what you need to do. Do you understand who you should represent? Are you looking at your prospective clients? There's a hazard in cherry picking. The first one is you're overlooking a lot of good cases. You're overlooking cases that should be paid and frequent filers and others. There's people who file everything, firms I'm talking about. You don't want to be that, but you don't want to be known as the firm that only cherry picks and takes the best and is turning away people who should get benefits. There's long processing times. The case that you're not sure of might get better. When I'm not sure, I sign the client up and I send a letter to their doctors. Call me if you want a copy of it. And it says, I'm not filing this letter, so you can't charge me, but please answer these two questions. One says, has your patient or will your patient be off work 12 or more consecutive months? Is your patient credible? Yes, no. I don't ask them to sign it. I get that letter back 2/3 of the time. It tells me if it's a good doctor or if it's a good client. Sometimes I'll have a good case and I find out I've got a bad doctor and I'll talk to my client about that. If you're only cherry picking, the judges also know you're not going to work too hard. They're going to pay attention to that on your decisions too, and you're going to lose a couple cases you should win. You also have an ethical problem if you're cherry picking. You're in a helping profession. Is it okay to stop taking SSI cases? I don't believe it is, but I won't get into that philosophical discussion now. There are some great children's cases. There are people who refuse children's cases, just flat out, we won't take them. It's easy to pick the children's cases that are good. First of all, if they have asthma, do they take Jim? It's not a good case. Do they go to the emergency room? If they don't, it's not a good case. There's a lot of easy ways to weed out the bad cases, but don't turn away those children who have good cases. If you're automatically avoiding anybody under age 50, anybody who's been convicted of a crime, anybody who's a drug user, you're turning away some good people. I speak to some drug clinics once a year, and I teach them how to help their people who with disability get their benefits. Government Accounting Office says 60% of the people with addiction problems eligible for disability never sign up. I talk to these clinics and I tell them if they have an addiction problem, they have a psych problem. Get them at least 10 visits with a psychologist. Get them a physical. And then if the psychologist thinks they're disabled, irrespective of their drug addiction, I'll talk to them. I've won cases for people who are cocaine addicts, heroin addicts, who meet the bipolar listings or the schizoid listings. And the people from DDS call and they'll joke about, you got us again. It's okay. If you can do it, you do it. Some states have rules that you provide pro bono services. Once in a while, it's nice to do it in an area in which you actually know what you're talking about. When you're filing an initial, respond timely to the district office and to DDS. It's important. I had somebody call me this week from DDS, and she said, "What did you send for?" I told her all the medical I sent for. She said, "Is there anything for me to do?" I said, "Just wait." She's going to get credit for working that file, but I've got a friend. See the case from their perspective. They have to push cases. They have to do a certain amount of work, solve their problems, give them the reasons and tools to help you, and they're going to help you. Adjust your responses to them accordingly. Here's my initial app letter to doctors. I tell them I'm representing them. I ask for their records and the forms. And in bold red on my letter, I say, your patient has no chance of receiving these benefits if you don't complete these forms. Throw a little guilt at them. It's okay. If the doctor works for one of the big institutions, sometimes they're not supposed to fill forms out or they have to send it to the legal department. I make it easy. I enclose a self-addressed stamped envelope, and I stamp on a post-it note, "Please complete this form, return it to me in the envelope I've provided before sending this letter to medical records." I get almost 2/3 of those forms back within a week, filled out by hand by some pretty fancy doctors, and then the letter goes to medical records and I get the records 3, 4, 5 weeks later. There's a lot of doctors who will help their patients if you make it easy for them. You have to be fast, thorough, and organized to make your intake work. Here's one that I found very interesting a couple years ago. A client came to me for an initial application on December 5th of 17. I filed the claim December 12th. I sent for medical records and an MSS to these doctors. I got the records from these doctors, but the cardiologist and the sleep specialist refused the MSS. So I then sent them another guilt letter, along with one to the psychiatrist. Psychiatrist assistant called, said, "We don't do that," followed up. Ohio records are free, but I then sent the high-tech letter explaining that they had a fine coming of $50,000 to $500,000 if they didn't send the records I wanted. I got great MSSs from the orthopedic surgeon, psychologist, and neurologist, which I filed with the state agency. Got an MSS from the cardiologist with records, which I then filed. In February, I got a call from the psychiatrist, and she told me she doesn't fill out forms, but she finally said she would for $1,000. I said, "How long does it take you to fill them out?" And she said, "It'll take me 15 minutes. I told her, "Okay, I'm going to tell my client to bring $1,000 to her next appointment, and I'm going to let her know you charge $4,000 an hour for filling these forms out." The doctor blew up at me, wanted to know why I wasn't paying it. I told her it's my client's responsibility. She finally agreed to fill the form out for nothing. In February, I sent a memo to the state agency. My memos are short and sweet. That's basically what's in it. If you email me, I'll send you what I put in my memo to the state agency. It's a merge doc. I have a field for all medical diagnoses. I have a field for all exertional restrictions, a field for all non-exertional restrictions. I had one paragraph summarizing everything and telling them why they should pay my case. The people at the state agency in Ohio know that if I say it, it's there. They don't have to look. They know I wouldn't say it if it's not there. In March, I got a favorable decision with $22,800 in past due benefits and a fee of $5,200. It was simple. It was an easy case to win, not much time. Took a little more than usual because this doctor and the assistant kept calling me. But here's another one that shouldn't have happened. This is Ernie, 56 years old, an SSI case. His best year's earnings were $3,700. Great medical. He met an orthopedic listing, met a psych listing, and he came close to meeting GI listings. Something smelled funny about Ernie, though. When I was preparing for his hearing, I said to him, "How much do you pay in rent?" He kept telling me not much, and he just didn't sound right. Took a lot of questions till he finally said, "Oh, I pay about $800 a month in rent." When I asked how he pays it, he kept telling me odd jobs, and I wanted to know how much he made. Kept saying not much. And after a lot of questioning, he says, "Well, I don't usually make more than $1,000 a week." Again, this is an SSI claim. I told Ernie we had to dismiss his case. He didn't want to because he's so disabled. I finally convinced him that the judge might turn him over to IRS. He might get indicted. I didn't want to sit in a hearing room with somebody like this. This should have all been found out by my intake person. They let it go by. Ernie sounded so disabled, they didn't ask the income questions on an SSI claim. Ernie finally agreed to dismiss his case. He then went to the bathroom in my office, came back, wanted to know who my landlord was because he said, "I need a new bathroom," and he'd give him a good price on fixing it. So, what do? You have to be careful. You have to pay attention. But never underestimate the difference you can make in the lives of others. Step forward, reach out and help. Starting right now, then tomorrow, then next week, and the rest of the month, and the rest of this year, and as long as you're practicing, help others that need a lift. People are calling your office so that you can change their lives. Don't miss out on this opportunity to make a difference in their lives and therefore in the world. That's what we're here for. That's why we're practicing. That's why we're doing what we do. So let's step up. Let's help that 30% who don't apply. Let's help the people who are calling you that we're missing out on and make the difference we should be making in the lives of the people we're representing. I'm glad to take any questions now. Nathan, I'm sure you have some for me.
I do. Thank you, Jim. That was terrific. All right. Well, we do have time for a few questions, and let me start with this one. Let me read it as it was sent to us. What do you do with good cases when you won't get paid at the initial level and they don't have a condition where it's necessary or advantageous to wait to file, but you're not going to get paid, he thinks?
Okay. Well, first of all, on initials, if it's Title II, if you look at them, the reason people get denied on initials most often is because they file too soon or because the DDS doesn't get the medical. So if it's a Title II case, I have people sign a form saying that I'm recommending they wait until they've been off work 4 months. If they're off work 4 months, the DDS doesn't get to review it until they're off work about 8 months. And at that time, they can believe that they're really going to be off work a year. If they apply a month or two after they're off, DDS gets it at the 6-month mark. They say, "How do I know they're going to be off a year?" And they turn them down. So I'll have, if you email me, I'll send you the form. I have people sign for that. If it's a Title 16, I don't do that because you're costing them money. If it's a terminal case, I don't do that. But Title II, you're doing a disservice if you sign people up too fast because they're just going to get turned down.
All right. And I'm going to apologize. We're having a thunderstorm here. I don't know if you can hear all the thunder outside. This firm wants to know, can a legal fee be made representing claimants on overpayments or fraud claims? We usually turn them away, but feel bad about doing that.
I represent 1 or 2 overpayments a month. And overpayments are interesting. You first have to look at them. Let me back up. If an overpayment case comes in, Don't have your intake department talk to them. Have them give it to you. But look at it and decide if you think you can win it. My policy is I want a retainer fee of 15% of the overpayment. Social Security and federal workers' comp have merged their computer system since early this year. They are sending out about 50 overpayments a month of $200,000 to $350,000 with the standard overpayment letter of please remit this sum within 30 days. I'm asking for 15% as my retainer. An air traffic controller on workers' comp is getting $90,000 to $120,000 a year. A postal worker on workers' comp is getting $60,000 to $70,000 a year. I've had 6 hearings now. The others that I've won without going to a hearing. Judges are thoroughly offended at the letters people are getting. But I get the retainer. I try to have a third party sign the contract and pay the retainer. If it's a third party paying you, you don't have to file a fee petition. So you can get a nice fee and no fee petition. If I don't think I can win it, I don't take it. So there are some overpayments that you can do very well on. And they're fun because they're out of the ordinary. Fraud cases are equally as interesting. I look at the case. If I think that there's no fraud and Social Security is way off base, I will decide what I'm going to do and what my retainer is going to be, depending on how vicious Social Security is trying to be toward the claimant. That's what my retainer is. Frankly, the Social Security fraud department, for the most part, wouldn't know fraud if it smacked them in the face. And I had one case where the judge actually filed a complaint against the fraud investigator because the fraud complaint included 3 hours of video, and during the hearing, it turned out that the investigator had over 100 hours of video, none of which showed my client working, but he didn't discuss that in his report. So there's a lot you can do. They're fun to do, and you can make a nice fee on them. Don't just make a rule that we're going to turn them all away. There's some good cases. You can help people, and you can have fun doing it.
All right. There was a reference that I made earlier about a call center. If somebody used a call center, is that in place of an intake team? What do you think, Jim?
No. What you're doing is you're redefining your intake team. I only know of 2 firms that have the call centers do all of the intake. And frankly, I don't like that. I think a call center can accept clients if they meet certain parameters. If you say the call center can accept anybody over 50 who's been hospitalized, who's got certain severe impairments, it still bothers me, but that's okay. I don't think a call center should ever be allowed to reject anybody. Most of the firms I know that use a call center have them answer the phone, do the guts of an interview, and depending on the clients, will either make them an appointment to be called by the firm or warm transfer them over. What I like best is the firms that will warm transfer everybody over 50 with a severe impairment, everybody under 50 who's been hospitalized within the last 6 months. But some firms just give the call center an appointment book and they fill it up with appointments. There's still a need for intake in-house to finish the appointments, to send the forms out and make the prospective claimant know that you're not being represented by a call center, you're being represented by a firm that's going to take good care of you.
All righty. Here's one. Sometimes the firms are getting calls now from clients who are having their disability benefits reviewed. Can they get paid on those, or what should they do?
Yes. There's a couple things. First of all, if you just get a call from somebody who has the first letter, there's not much to do on that. If they're actually told that they're being terminated, judges are very upset. And I was on a conference call a year and a half ago with judges from the Judges Union who are upset that lawyers aren't representing people on these because they felt they're having to turn some people down that wouldn't be turned down if they were represented. So you will keep most of the judges happier if you represent the continuing disability reviews. Next question is, how do you get paid? I recommend that you get the debit card number of the claimant and you find out what day the money goes into their account. And then you say, what I do is, if I didn't represent them at the hearing, so I've never made any money on them, I take 20% of their check every month and put it in my trust account. If I did represent them, I take 15% and put it in my trust account. When I win the case and have the benefits continue, then I file my fee petition and have that amount of money as my fee. I also pay any expenses I get as they're incurred. And that way you're getting it. If you ask the people to send you a check every month, they're not going to. If you have the credit card number and you put it into your bank account every month, you have it every month. Invariably, if you're doing it long enough, somebody's going to call and say, this is a terrible month. Can you skip it? And that's part of our practice. You'll skip 1 month as long as you're being paid regularly. But you're doing a service to people who need you, and you'll get some good brownie points with the judges.
Okay. I'm going to squeeze in one last one, and that question is, what is the biggest mistake you see firms and their intake teams make?
Boy, where do I start? Okay, the biggest mistake I see is that the firm owner creates by themselves or with the help of people in the intake a form to fill out. And they say, fill this form out, and if they answer these questions this way, sign them up. If there's any no answers, reject them, and they don't look. It's the representative or the attorney's firm, and they have to look. They have to constantly pay attention. And they shouldn't allow an intake department to reject a client unless the person is working and making above substantial gainful employment levels. They shouldn't allow or if they're over 65, certain things. But in general, the owner of the firm has to pay attention to intake. They have to spot check some of the people who are rejected. And when I say spot check, call them. Find out what their facts are. That's important. The other biggest mistake, and this is a malpractice eligible mistake, is your malpractice insurance says you have to write every person you talk to that you're not taking and say, thank you for contacting my firm. Sorry, we can't represent you. You have to create a paper trail. I recommend that you put something in there that says, we can't represent you at this time. Please contact us when you stop working, if your circumstances change. Have a brochure and send your brochure. That 20-year-old with a sprained ankle that you may never represent has parents in their 50s. Maybe their parents are going to be disabled, or maybe somebody they know is. Send them that letter, send that brochure, Let them know you cared enough about them to say, thank you for calling. Here's my brochure. If I can help you or anybody you know, I'm available. And don't fill out a form, be all businesslike, and act like you don't really care about that person. Part of intake is letting people know that you care about them and anybody they know, and you're going to be there if anybody they know needs you. And that's how you build your practice. That's how you get the best cases.
All righty. Well, there were more questions than that, so we will do our best to follow up with you afterwards, and you may think of some questions later on. Jim or I here and my team at Formidable, we would be happy to talk with you directly after the program. As a reminder, once you leave today's webinar, once you leave today's webinar, sure.
Okay. Yep. I've scheduled nothing for the next 45 minutes. If anybody has a question to call me about, or if you want any of the forms or letters I mentioned, just email me and I'll shoot them out to you.
All right. Well, that sounds like an offer. All right. So afterwards, you're going to get a recording and you're going to get a survey. We ask you to share the recording with people you think would benefit from today's program and fill out the survey so we bring you the quality programs you want to hear. Thank you, everyone, for attending today's webcast. On behalf of Jim Brown, plus the entire team at Formidable, thank you for joining us today. Now go out there and get some more great cases.